Morning to everyone who is in the United States or in our time zones. Welcome to people joining us from Germany, elsewhere in Europe, and indeed from around the world. I'm Jeff Rathke, president of the American German Institute, and we are really honored and privileged to be able to offer this webinar today, which is about the question of party bans in Germany, and in particular with reference to the far-right Alternative for Germany party known as the AfD. This is a pretty timely conversation, I think, because just yesterday we had in the U.S. Congress a hearing which was about freedom of speech and related issues in Europe. And we are, of course, having this conversation today against the backdrop of what I would say is an inversion of the values issue in transatlantic relations. For decades, the fundamental shared values between the United States and Europe have been a life ring that we have reached for whenever we've encountered periods of difficulty between the United States and our European allies. We have re-emphasized that we share fundamentally similar views of human rights, of political freedoms, and of these basic values at the heart of our governments and our societies. And what we've seen in recent months is a change in that approach from the United States, where the United States has accused its closest allies of violating values, of abrogating in some ways the Trump administration's view of values and rights and freedoms. And so in this time, it's particularly important for us to understand the views and the legal and political framework in Germany as the question of a possible ban of a political party rises. This is something we followed here at the Institute before, and I'm about to hand over to my colleague, Dr. Eric Langenbacher, who has done so much work on this topic, and he will introduce our guest, Marco Buschmann, and get us started. So with that, Eric, let me hand it over to you, and I'm going to look forward to the conversation.
Thanks, Jeff. And good morning or good afternoon to everybody who is attending today. I'm Eric Langenbacher, Senior Fellow and the Director of the Society, Culture, and Politics program at the American German Institute. And I'm really pleased to introduce our speaker today. We have Dr. Marco Buschmann, who is a lawyer and a member of the Free Democratic Party, the FDP, the Liberal Party in Germany. Buschmann was the Federal Minister of Justice in the last government headed by Chancellor Olaf Scholz. He oversaw Germany's legal system, including analyzing the legality and constitutionality of laws prepared by other ministries. He also served as a member of the German parliament, the Bundestag, from 2009 to 2013, as well as 2017 to 2025, and also intermittently served as the Secretary General of the FDP. Minister Buschmann studied law at the University of Bonn, having graduated in 2004. Then he went on and completed his doctorate at the University of Cologne, conducting analysis of the origin and content of EU property law. So we're really thrilled to have Dr. Buschmann, former Minister Buschmann, with us today to walk us through the procedures that are in place regarding banning potential parties, and specifically the most current procedure and proceeding which has been directed at the Alternative for Germany. So, Dr. Buschmann, the floor is yours. I should tell everybody that Dr. Buschmann will speak for about 15 minutes, and then we'll open it up to a question and answer period. The way that we do it here at the American German Institute is we ask anybody who has a question to type it into the Q&A function, which you can find at the bottom of your Zoom screen. And then I will collect some of these questions and then read them off to Minister Buschmann. So without further ado, Dr. Buschmann.
Jeff, Eric, ladies and gentlemen, thank you for the warm welcome, and I'm very pleased to have the opportunity to speak to such a distinguished audience about the General procedure for banning political parties. First, I would like to thank Jeff and Eric and their team at the American-German Institute for this opportunity. And more generally, I would like to add, one cannot do enough to promote exchange, mutual understanding, and I would add friendship between the USA and Germany at all levels, because even it may not yet be clear to everyone, but all committed supporters of liberal democracy will be heavily dependent on that friendship in the challenging times we are already in and in those that lie ahead. Before diving deeply into the topic of the lecture, I would like to make a preliminary remark. I've often discussed the topic of party bans with students, with lawyers and politicians from the United States. And the reaction is always similar. It's deep skepticism. And I can understand this skepticism very well. It reflects the democratic instinct of the American people against the backdrop of a historically evolved two-party system. The idea of wanting to ban one of these two parties is indeed at best curious. In fact, that would be a threat to democracy if voters' practical choice between two parties were reduced to just one. We would have conditions like those in the Soviet Union or the GDR. But to be able to assess the instrument of the German party ban fairly, in my opinion, two things must be kept in mind. First, since the mid-19th century, Germany has been accustomed to party systems with significantly more than two relevant parties. Currently, a total of 6 parties is represented in the Bundestag, which is our parliament. Against this backdrop, the ban of a political party does limit the choices for voters, but it does not reduce them to a single party. Nevertheless, such a restriction of choices remains, as the Federal Constitutional Court in Germany puts it, the sharpest and at the same time a double-edged sword of the democratic constitutional state against its organized enemies. Therefore, it must be used with the utmost restraint. Even more important, however, is the second point. The Federal Republic of Germany was built on the ruins of the Weimar Republic, which the Nazi terror had left behind. The Nazis originally gained power through elections. This led the founding generation of the Federal Republic of Germany to the concept of wehrhafte Demokratie. Karl Löwenstein once introduced the term militant democracy in English, but in my ears it sounds a little bit too aggressive. Personally, I would prefer the term defense-ready democracy. That means capable to defend against attacks. Independent of the terminology, the concept of wehrhafte Demokratie is if political parties seek to overcome democracy through elections, then democracy must be able to defend itself against such parties in time. The Weimar Republic did have a procedure for banning parties. Several times there was discussion about permanently banning the NSDAP, which was a Nazi party, but it was never put into practice. Thus, the founding generation of the Federal Republic of Germany repeatedly asked themselves, could a consistent and timely ban of the NSDAP have prevented 80 million victims of World War II and 6 million Jews who were brutally murdered in the Shoah? In view of so many people dead, with so much cruelty and suffering that emanated from Germany to the world, no one of that founding generation wanted to dispense with this instrument. After all, it was conceivable that one day it could contribute to what we in Germany express in the formula never again. Well, now let us get a little bit more technical. The legal foundations for a party ban procedure under German law are as follows. Article 21, paragraph 2 of the German Basic Law, which is our written constitution, states, parties that, by reason of their aims, all the behavior of their members seek to undermine or abolish the free democratic basic order, or to endanger the existence of the Federal Republic of Germany shall be unconstitutional. According to paragraph 4, only the Federal Constitutional Court decides whether a party is unconstitutional. And under paragraph 5, the legislator has the right and the duty to regulate further details in federal law. The German legislator has exercised this regulatory power in the Federal Constitutional Court Act. There in sections 43 to 47, provisions are made with more details on the party ban procedure. A respective application of to the accord can be made by the German Bundestag, which is our parliament, the Bundesrat, which is a representation of the federal states, and the federal government. If the Federal Constitutional Court concludes that the application is admissible and well-founded, Section 46, paragraph 3 of the Act stipulates the following legal consequences. First, dissolution of the party. Second, prohibition of the establishing a substitute organization. And third, regularly confiscation of the party assets if there are any. To date, the Federal Constitutional Court has ruled 6 times on the unconstitutionality of a political party. However, with respect to the proceedings against the so-called Nationalist and the so-called Free German Workers' Party, the court held that these entities did not qualify as political parties. Accordingly, proceedings for the prohibition of a political party were not applicable, hence the court has ruled just 4 times in substance. These 4 substantial decisions can be divided into 2 early ones from the 1950s and 2 later ones from 2003 and 2017. In the early decisions, the court applied the party ban assertively. The later decisions, however, significantly narrowed the practical scope. In 1951, both the Bundestag and the federal government filed an application concerning the Socialist Reichspartei, SRP. The SRP was not very strong. It was a little bit strong in Lower Saxony, in Bremen, but they have no seats in the Bundestag. But the Federal Constitutional Court found it proven that the SRP deliberately targeted and organized former Nazis to promote the re-establishment of a National Socialist state and thus sought to overturn the free democratic basic order of the Federal Republic of Germany. Accordingly, in this judgment of 24th of October 1952, the court dissolved the SRP, banned substitute organization, and confiscated the party assets. Also in 1951, the federal government applied to the courts for ruling on the unconstitutionality of the Communist Party of Germany, KPD. The KPD had a Marxist-Leninist platform and little political influence. At the time of the application, it held 5.7% share of the votes for the Bundestag. The court found it proven that the KPD sought to establish a dictatorship of the proletariat following the Soviet model and thus intended to abolish the free democratic basic order. It determined that due to the party's close ties to the GDR and the Communist International, as well as its systematic infiltration of state structures, there was a real danger. And accordingly, in its judgment of 17th of August 1956, it dissolved the KPD, banned substitute organization, and confiscated the party assets. This decision was made at a political turning point. From around 1956, 1957, a clear party system emerged in the Federal Republic of Germany, consisting of the CDU-CSU, the SPD, and the FDP. The CDU-CSU integrated forces from the right of the center into the democratic consensus. The SPD transformed from a Marxist-Leninist-inspired workers' party into a people's party, integrating forces from the left to the center. And the FDP positioned itself in the political center. Economic and political success led to high satisfaction with the political system and its parties. The result was great stability. Extremist parties played no role. From the 1970s onward, this led legal scholars to conclude that the requirements for banning a party should be set significantly higher than in the early party ban cases. However, for a long time, this remained a purely academic discussion, as no new party ban proceedings were initiated. In 2001, Bundestag, Bundesrat, and federal government filed applications with the Federal Constitutional Court seeking a ruling on the unconstitutionality of the far-right National Democratic Party of Germany, NPD. Apart from some local council elections, the NPD had no electoral success. However, it was regarded as a kind of organizational hub for numerous far-right crimes, ultimately aimed at overturning the free democratic basic order. The case was not successful. It emerged that numerous party officials were working as undercover informants, we call it in Germany V-Leute, Verbindungsleute, for the domestic intelligence service. The court noted that this was problematic. It was impossible to determine clearly which statements could be attributed solely to the party and which might have been influenced by state agents. The court therefore required that the identities of all informants be disclosed. The applicants refused to do so, and so the proceedings were discontinued. In years that followed, the NPD became increasingly entrenched in the eastern federal states, entering the state parliaments of Saxony and Mecklenburg-Western Pomerania. In the debate over a new ban proceeding, the Bundestag and the federal government refused to file another application. At the end of 2013, however, the Bundesrat decided to file an application with the court on its own. All undercover informants had been deactivated beforehand to avoid the evidentiary problems of the first NPD ban case. On 17th of January 2017, the court issued its ruling. It confirmed that this time there was fully admissible evidence. It was also found proven that the NPD pursued anti-constitutional goals and acted against the free democratic basic order in an aggressive and combative manner, and implementing their goals in a systematic way. According to the standards set in the SOP and the KPD cases, the court would normally have banned the party. However, it now required that a third criterion to be met, so-called potentiality. This criterion reflects the legal discourse of the 1970s. Potentiality means that there must be concrete indications which at least make it appear possible that the party's conduct directed against the protected interests of the free democratic basic order may be successful. According to the court, these protected interests are human dignity, the democratic principle, the rule of law, respect for fundamental rights, the multi-party principle and the equal opportunities of political parties, and the right and possibility of recognized opposition. In the court's view, the NPD was politically too insignificant and entirely isolated for such a danger to exist. The party had no realistic prospect of achieving its anti-constitutional aims, and so the court therefore rejected the party ban. For several years now, there has been discussion in Germany about whether to file an application to determine the unconstitutionality of the alternative for Germany, the AfD, which is a right-wing populist party having impressive success, especially in Eastern Germany. Both legal and political consideration must be taken into account in this matter. Well, from a legal point of view, the following can be said. There is a considerable body of evidence that large parts of the AfD membership hold views contrary to the free democratic basic order. The most well-known faction is the so-called Flügel, the wing, led by Björn Höcke. Höcke promotes racial theories, uses Nazi slogans, and repeatedly employs phrases used by prominent Nazi leaders. The Federal Office for the Protection of the Constitution and the corresponding state offices classifies a party as a whole as confirmed right-wing extremist. But thoughts and views are not enough for a ban. There must also be evidence that these part of the party intend to act in an aggressive and combative manner against the free democratic basic order. Well, some people mention Höcke's aggressive speeches with Nazi slogans in that context, but words and speech are not enough. Action is necessary. Some mention the behavior of the AfD's parliamentary groups, and they obviously and regularly have been regularly behave in a quite obstructive manner, but being obstructive in parliament is maybe no clear evidence for the will to abolish parliament. Hence, that criterion is potentially a weak point in the line of arguments used by the advocates of a respective banning procedure. The thorniest problem is a question of potentiality. We know the protected interests. We know that in its two early decisions, the court held a theoretical danger for sufficient. Even a party with no seats in the Bundestag, remember the SRP, was dissolved. But in its later decisions, the court asked for a higher degree of danger. That is the very idea of potentiality. Some argue that the degree of danger must not be too low. Otherwise, it would be a motion of no confidence in the strength of German democracy. Others argue the degree of danger must not be too high. They remind us that for a long time, Hitler was politically underestimated. Personally, I'm under the impression that most experts in Germany think that in a proceeding regarding AfD, it is unlikely that the court would hold the degree of danger for sufficient. On top of that, no one can reliably predict whether the Federal Constitutional Court would modify its criteria again. There is no principle of stare decisis in German law. So from a legal point of view, in my opinion, the best case is a 50-50 chance of success. The base case is even poorer. Politically, the following should be considered. If there is no reasonable certainty that the ban application will succeed, it should not be filed. An unsuccessful proceeding is always a propaganda bonanza for extremist parties. The first NPD ban cases demonstrated this. Before the proceeding, the party was not represented in any state parliament. After the case failed, it entered 2 state parliaments. Additionally, you have to regard in some parts of Germany, the AfD has a 40% voter support. These voters will not simply return to a traditional party if their preferred party is banned. Many of these people will be very angry. Another party with a similar platform would likely emerge to capture this electoral potential. For this reason, my personal view is that it would be a mistake to file a ban application. If it fails, it strengthens the AfD. If it succeeds, it does not solve the underlying problem. And that is that so many people in Germany have become disillusioned with the serious democratic parties of the center. Unless one truly understands why that is, and how to change it, the problem will not be solved by a party ban. Thank you very much.
Thank you. That was incredibly informative. So before I get into the Q&A, I have just a couple of questions for clarification. So obviously, this is a very partisan issue in German politics. And I know that the various parties, well, not the AfD, which is obviously against this, but the other mainstream parties have differing stances. The SPD, for instance, they had a party meeting where they unanimously called for supporting a ban. The Greens seem to be for a ban. Your party does not think that it's the right move. The CDU-CSU seems divided, but Merz doesn't seem particularly supportive of this as well. So my one question is, so this is all prompted by the determination of the Federal Office for the Protection of the Constitution, the Verfassungsschutz, that is a confirmed extremist party. So my question is, how long does that determination, how long is it valid? So let's say that in 4 years, there is a change in government again, and you have a left of center government with the parties for the ban. Can they still initiate even 4 years later? So like, how long does this determination stand?
Well, it's a very good question because you have to differentiate between the party ban proceeding in the court, in the Federal Constitutional Court, on the one hand, and the proceeding of the Federal Office for the Protection of the Constitution. You have to differentiate it. The Office for the Protection of the Constitution has no right to applicate for a party ban. It's a kind of domestic intelligence service, but with very limited authority. They can collect information. And then the federal government or the parliament or the Bundesrat can use this information to form its own vote for or against application. And these information stay valid as long as they are correct. The Federal Office for the Protection of the Constitution has a 3-level system, and the highest level is this proven right-wing extremist level. And under German law, they need to have clear evidence for that. And as long as this evidence exists, they can uphold this qualification, and a government can use the information. But to make the thing clear, the German government or parliament is not necessarily bound to the qualification by the Office for the Protection of the Constitution. It makes its own decision and has its own responsibility, which is checked by the Federal Constitutional Court. And yes, you are right. In some years, it may be possible that a new German government decides that it should make an application. That's absolutely possible. There is a current procedure in courts because the AfD has the possibility to file an application against that qualification, and they use this possibility. And it might be the case that in 1 or 2 years, a court may decide that under German law, the level, the third level of proven right-wing extremist is not fulfilled, but it's very unlikely because several branches, federal state branches of the AfD made such applications, and most of them lost the cases. So it's very likely that German courts will uphold the qualification at a right-wing extremist, a proven right-wing extremist.
All right, and then I also had a couple of questions, and I'm starting to channel some of the stuff that's coming in through the Q&A function. So has anybody ever been put into jail because of, you know, being a member of a confirmed extremist group? So is that a possibility? And then on a related topic, you mentioned Björn Höcke, right, who has there've been fines levied at him for using certain kind of like Nazi words. Can somebody be put into prison in Germany for saying something pro-Nazi or what have you?
Well, once again, you have to differentiate. The party ban procedure is no criminal procedure. And even if you're a member of a banned party, that as such is not a crime. Nobody goes to jail because of being member of a political party, even if it's banned. But in Germany, we have regulations under our criminal code. There are regulations that if you use Nazi slogans, that can be a crime. And yes, Björn Höcke was convicted for using Nazi slogans which are forbidden under German law. For example, if you deliberately use SS slogans under German law, that's a crime. You don't go to jail for that. You have to pay a certain amount of money. You need to do it very regularly, 5, 6, or 7 times that the German court would send you to jail for that. But from a formal legal point of view, that's a crime under German law.
All right, before I get into other questions that have come in, I think, Jeff, you have a question.
Well, thanks so much, and really terrific presentation. You alluded, or you discussed the change in the criteria that the Constitutional Court applies, and in particular, the potentiality criterion that arose after the first 2 successful bans of parties in the 1950s. I wonder if I could draw you out a little bit more on your own personal assessment of the potentiality criterion, because as you noted, you know, if you think retrospectively about the situation around the NSDAP, there is this conundrum that if it doesn't make sense to ban a party when it is small and weak, it is even harder to ban a party when it is growing in strength. So how do you feel Germany should be, in German jurisprudence, should be wrestling with this problem of potentiality, which appears in a much different light today than it did in the 1970s when the idea first really started to take root?
Oh, well, that's an excellent question, and it's a wonderful field for academic speculations, and lots of German scholars participate in that debate. And you may argue that the degree of danger which is necessary reflects the self-confidence of a democracy. In the early years of the Federal Republic of Germany, this was an experiment. Nobody knows whether it will be successful. And so lots of members of the founding generation said, well, no new Nazi party. We saw all this, please, I have to excuse for that. We saw all that shit. And we don't want to see it again, so they use the instrument assertively. Some decades later, most people in Germany were convinced, okay, democracy is a good thing. We are very successful with it. Our life is good. We support democratic parties. We don't want any extremist parties. So the self-conviction in the German democracy was very, very high. And so scholars said, well, the extremist parties have no chance, we don't need that. And so this criterion of potentiality was developed. Today, that conviction is not as strong as some decades before. We saw the storm of your parliament in the US, and the US was always the lighthouse of democracy. We saw what happened with our neighbors in Hungary and Poland under the PiS government. And we see the success of extremist parties all over the world and in Germany. And so you can speculate that perhaps the judges see these developments as well, and it might be the case, but nobody knows, that they lower that degree. And from an academic, it's a wonderful issue to write papers. But my view, when I was minister, was another view. I have to take the responsibility for doing it or not. And so my personal view was the danger to support the AfD, but with an unsuccessful proceeding is too high, because that's always a propaganda bonanza for an extremist party. And that is why I'm not so assertive. The second thing is, why are parties like SPD Greens or the Left Party in Germany so strong for a ban as they do? Regarding SPD, this has something to do with their history and their tradition. One pillar of their identity is the fight against right-wing extremism. And it goes back to a very important speech made by Otto Wels in the Reichstag when the Nazis abolished the democratic order in the Weimar Republic. All the moderate parties deliberately dissolved their own existence, but the SPD voted against this Nazi laws. And Otto Wels said, you can beat us, you can kill us, but you cannot take our pride away from us. And that's very important for the identity of SPD. The fighting right-wing party is part of their identity. The Green Party has a conviction that the AfD is really a dangerous party. That is true, but they had some gains from it, to be honest, because for several years there were two extremes among the relevant parties in Germany. On the one hand, the AfD, and on the other hand, the Green parties. And both had advantages from that situation. Both growth. And so the Green Party tried a lot, did a lot rhetorical attacks on AfD, and AfD to the Green Party as well, because that improved or that escalated the polarization, and both parties had gains from it. That changed in the course of the last years. Now the left-wing party is even more successful than the Greens, and they took the positions. And both have an advantage from it. The left-wing party to attack the AfD, and so we have to ban them, and on the other hand, the AfD. And that is not my speculation. We have official strategic papers from AfD, and the AfD states it's wonderful to be attacked by the left-wing party and the Green parties because that escalates the polarization, and we are one part of this polarization. We are one pole in this polarization, and so the gains are ours. And so that explains a little bit why these parties are so loud. And on the other hand, that explains why the moderate parties, like my party or the CDU-CSU, said, no, we don't want to escalate that polarization. We want to solve the problems that cause the disillusionment of the people regarding the serious parties, and that's a better way. I hope that makes it a little bit understandable why what party decided for a special strategy regarding AfD.
Thanks.
All right. We're getting a lot of questions for more clarification on certain points because this is, very different from the way things work in the United States. So first of all, there's a question about the report from the Office for the Protection of the Constitution not being made public, not being published. I mean, it was leaked, so people were able to see it, but maybe you could let us know why that wasn't automatically published. And then another question, which I actually kind of wonder myself. So let's say Höcke doesn't pay the fines that are levied against him, just refuses to do so. Could he or somebody else in a similar situation actually be imprisoned for not paying the fines?
Well, the second question is easy. In theory, yes. If you refuse to pay the fines, there is a possibility to send you to prison. However, you need to regard the principle of proportionality. And it may be the case that a judge would assume that for Höcke, it's a wonderful PR event to send him for some days or a week or two to prison. And so theoretically, the answer is yes. But it's hard to predict what a concrete court would decide in that case. The first question is absolutely understandable. And my personal view is that's really a problem, but the idea, the ratio behind the regulation is that the Office for the Protection of the Constitution is, they don't like to hear it, but is a kind of intelligence agency. And at that highest level, proven extremist party, they are allowed to use means of an intelligence agency. For example, technically monitoring, acoustic surveillance or telecommunication surveillance and so on. And they are allowed to use undercover informants and so on. And if you dissolve all information you have received, you may conclude who are the informants. Perhaps the party can analyze what are the tactics to collect information. And that is the ratio that these reports are a kind of state secret. My personal view is that it's really a problem for the acceptance but that is the relevant German law.
And then just finally, one more technical question. Given the past cases that have gone to the Constitutional Court, do you have any estimate, were this proceeding to be forwarded to the Constitutional Court, how long it might take for them to deliberate and to come to a decision?
Well, that's a very good question. Some cases took years. Think of the KPD case. It was applicated in 1951, and the decision was made 5 years later. The NPD case took a lot of years, and there are two reasons for that. One is the court wants to show that it takes the matter very seriously. So a lot of hearings are made, lots of witnesses are heard, a lot of experts are heard, a lot of discussions are made in front of the court or before the court, and the court takes a lot of time to reason very seriously about the matter. And so it may be the case it took 3, 4, or 6 years. That's absolutely possible.
Well, okay, that's very interesting. So we're getting a lot of questions here, and I'm going to try to channel them. They're kind of like, much bigger picture questions. We have one that's talking about how the Party Ban Proceedings, which go back to the 1949 basic law, that could have been justified in the 50s, obviously, because the history, the Nazi past was just a few years before. Do you think that in a mature liberal democracy like Germany today, that these procedures are even needed?
That's an excellent question. Frankly, that is exactly the view of the legal scholars in the 1970s. And frankly, that's a ratio behind the criterion of potentiality. Jeff mentioned the idea, well, if the party is too small, there's no potentiality, and if the party is too big, you cannot ban the party as well. And it sounds a little bit crazy. Frankly, that might be the ratio behind the criterion. That is, in truth, a kind of abolishment of the party ban procedure without putting it out of the Constitution. And so some people think that's exactly the idea. But my personal view is there is a little bit change, and that has a lot to do with all the events I mentioned some minutes before. We see that in a liberal democracy that worked for decades very well, things can go very wrong. We see that even in the lighthouse of democracy, the United States, that people try to storm your parliament and things like that. So there's a lot of insecurity. And so I think that's not the bigger part of the legal scholars, but there are more and more that come to the conviction that perhaps we are not as established and not as secure as we thought some years ago. And that's the situation of the discussion in Germany.
Now, another really big question. I think you touched on this before, that your party's position is you're not for the ban, but rather that the issues and the factors that are driving support for the AfD should be addressed. So maybe you could provide a few more details on what exactly your party might, or you yourself might advocate for to address the reasons for support behind the AfD in the first place.
Well, we know what's the driver? What are the drivers for the AfD success? There are a couple of issues. At first, there is migration. Second is crime. And the third is that lots of people are in fear regarding their economical situation. You know, for decades, Germany was the economical powerhouse of Europe, but in the course of the last year, we start struggling in this regard. And so lots of people fear that they will lose their jobs, cannot pay their houses, and so on and so on. And so in my party, the preferred strategy is get rid of these problems, solve the migration problems, solve the economical problems, solve the problems of the security issues. And if we solve these problems, the AfD will not dissolve, but the success, they will not, the party will not be successful the way it is now. And this is not just a naive dream. We had a similar situation in the 1990s. Migration was a big issue, and there was a right-wing party. It was called the Republicans, the German party, not the US party. And they were very successful, and the driver was migration. And after that, the Democratic Party of the Center, CDU, CSU, SPD, and FDP made a change in migration policy. We even changed some stipulations of our constitution. And after that, the Republicans disappeared. And lots of people argue that that is the best strategy to make a successful extremist party small.
All right, well, we are rapidly running out of time, so I think we only have time for a couple of more questions. But here's one. I mean, it's no surprise to anyone on either side of the Atlantic that there are some voices in the United States that have been quite critical towards these proceedings and whatnot in Germany. I know that Vice President J.D. Vance has expressed criticism. Secretary of State Marco Rubio has, and of course we have I guess the unofficial government employee for a while, Elon Musk, also saying some stuff. But it's not just that. Tom Cotton, senator from Arkansas, has also expressed criticism. So how are Germans, especially Germans in the political class, reacting to these criticisms from the United States? Is it causing any kind of reflection, a change of minds, or is it not having an impact at all?
Well, I think you can differentiate between two groups in the so-called political establishment or among members of the political elite. There is one group that says, we understand that because that skepticism is not very new. At the beginning of my lecture, I mentioned that. I know that for lots of years. Even in Germany, if you discuss it with students at university, their view is our democracy is strong, we don't need that. So there is a reflection, we take the argument seriously, and to be honest, legal scholars in the 1970s developed ideas to restrict the scope of the instrument to cases that are more or less impossible. The restrictions are so high that especially the Green and the Social Democratic Party consider, do we have to change our constitution because the criterion of potentiality makes it more or less impossible to ban a party. So there is a serious core in that argument, and we take it seriously. On the other hand, there are people who say, okay, there may be a serious core, but honestly, J.D. Vance and Elon Musk use it as a propaganda bonanza. They want to explain their supporters why they are so critical to Europe. Some decades ago, these were our friends, our allies, and we share the same values. And if they now impose high tariffs on us, you have to explain that. And lots of people here think that that's a kind of rhetoric strategy to show that the Europeans are not the nice people we know in past. And so it's okay if these people are not nice to impose tariffs on them. That's more or less the argument, and there are a lot of people who think it that way here in Germany.
All right, so I'm going to pose one final question, which is maybe the biggest question of them all for our audience, especially those that are zooming in here from the United States. I think that as much as there have been shared values on both sides of the Atlantic, there are different emphases, different definitions of what something might be. And I think the one thing that many Americans struggle with is our understanding of free speech, freedom of expression, seems to differ a bit from the German one. So maybe you could share some final thoughts on how you think Germans define freedom of speech and how that differs from our conception in the United States.
Well, I think the conceptions are quite similar. The principle is everybody can say whatever he wants to say, except for he violates criminal law that preserves personal dignity. As far as I'm informed, there are criminal regulations in the US as well, that if you call someone an idiot, that you get in trouble with the police. But I'm not an expert in criminal law. That's the same conception as we have in Germany. But the one difference is really that we are very sensitive to Nazi propaganda and to racial issues because of the Shoah. It's very clearly. We are very sensitive to that, and that, I think that's a crucial difference. Because of our history, we decided there is one additional exception for the freedom of speech, and that is Nazi propaganda, anti-Jewish propaganda. And so we have some criminal regulations regarding that issue. But the idea is the same. Everybody can say whatever he wants because discussion is necessary for finding truth. It's a John Stuart Mill argument.
Well, it's always nice to end on a John Stuart Mill note. So let me thank you, Dr. Buschmann, for spending this time today. I found it to be hugely informative and insightful. And I also want to thank all of our participants who have asked questions or who zoomed in to listen.
Thank you so much.
Goodbye.
Bye-bye.